Hi, I'm Jason Sullivan of Rathbone Group, and this is On Subrogation, your free video resource for your subrogation questions. I'm a licensed Florida attorney, and in this video we're going to discuss Florida PIP subrogation. PIP is personal injury protection, which is a required and mandated coverage for any Florida auto policy. It covers, if you have an emergency condition, up to 80% of your reasonable medical bills caused by that collision, up to $10,000. If it's not deemed an emergency condition, the cap is $2,500. It also covers up to 60% of lost wages, up to $10,000, and there's a death benefit for $5,000 for a death caused by an auto collision. If you've paid out PIP in Florida, you may be looking for ways to recover. The general rule is that there is no PIP subrogation in Florida. There are two important exceptions, though. The first exception is if the at-fault party was uninsured. If they did not purchase the required insurance in Florida, they can still be pursued for the damages and the PIP coverages that an insured pays out. The other exception is the commercial vehicle exception, and this is where Florida gets a little confusing and is different than other states. I always tell people, if you work in New York or New Jersey, just throw out what you know about the commercial vehicle exception, and you have to start fresh looking at the rules in Florida. So what is a commercial vehicle? A commercial vehicle is anything that's not a private passenger motor vehicle in Florida. So what's a private passenger motor vehicle? That's any car, sedan, station wagon, or Jeep type vehicle, or any truck or van that's not used primarily for business or occupational purposes. So we are looking for trucks and vans that are generally used for occupational or business or professional purposes. If you have one of those, then you need to make sure that your insured falls into one of two important criteria. The first is they have to be a passenger in that commercial vehicle. If they're a passenger in any other motor vehicle, you're not going to be able to pursue subrogation. The other exception that allows for subrogation is if your insured is not a passenger in any vehicle. In other words, if they're a pedestrian, if they're on a bicycle. In those situations, if your insured is struck as a pedestrian, then there may be a right of subrogation against the at-fault party. It's important to know that that right of subrogation is against the owner of that commercial vehicle or their insurer, and fault plays no part in this. If that commercial vehicle is involved and your insured is injured as a pedestrian or as a passenger in that commercial vehicle, then you may have a right of subrogation against that other carrier. If you are looking at another state that defines commercial vehicle by the size or the weight, don't fall for those arguments that those vehicles are not commercial vehicles based on their size. Florida has distinctly ruled that it's based on whether the truck or van is used for commercial purposes, and the size of that vehicle does not matter. If you have any questions on subrogation in general, or you have a topic that you would like to see us cover, please email us at video@rathbonegroup.com. For Rathbone Group and On Subrogation, I'm Jason Sullivan, and that's the long and short of it.